Good afternoon, everyone. Let's get started. I want to make sure we have as much time as possible for the panel. Well, welcome to our first Alumni Speaker Series of the year. Really excited to have you all here. I'm really excited to be here too because I have been interim dean for about 24 hours now, so very excited about that. But really excited to have this panel here today. The panel is going to be focusing on intellectual property, and we have some really great speakers. We have 5 experts who are our alumni, who are out there doing intellectual property law in the community in a variety of different capacities, and you're going to hear a lot from them today. I want to turn the program over to our moderator, Mikhail Murshak, who is an IP attorney for Burris Law. He specializes in patent acquisition and enforcement. He has a BS in chemical engineering from Michigan State and attended law school at University of Connecticut. And he's been to practice in Michigan, Connecticut, New York, and for the USPTO. So I'll turn it over to Mike, and just really excited to see all of you here today. I hope you enjoy the panel. Thanks.
Thank you, Dean. Appreciate it. Thanks everyone for coming. I hope you guys are enjoying the lunch. And we have a really strong group of panelists here, so I'd like to thank them for taking the time to join us for this discussion. I've participated in these before, and they're always really interesting, and I think it's an advantage. You guys were smart to show up. It's a real good opportunity to be able to speak to real-life practitioners about their path, about how they arrived at where they are, about advice they may have for you, and things to choose while you're still here in law school. I've worked with some of you. Actually, three of the 5 panels I've actually worked with in the past, so it's pretty cool. Everybody here, besides myself, is an alumni of Wayne State. So starting to my left is Jennifer Woodside
Wojtala.
Wojtala, yes, I didn't want to butcher the rest of your name. We have Cesare A, Sclafani. We have MacCallum and Mark Frentrup and Lauren Edelman. Lauren and Michael are from Brooks Kushman, so local Detroit area law firm. Mark and Jennifer are from Harness Dickey, and Cesare is from Dinsmore, formerly Gifford Crass, but they joined Dinsmore about a year ago. So I worked with Cesare and I interned with Jennifer. We were in the same internship class, and at the time, Mark was one of the chemists, attorneys / partners that as interns received work. So I'd like to first give you guys a chance to introduce yourself, talk about your technical background, maybe your undergraduate and law school experiences, and how you arrived to where you are today. We can start with Jennifer.
Okay. So again, I'm Jennifer Woodside Wojtala. I'm at Harness Dickey in Pierce. I'm a partner there. My undergrad is in chemical engineering, like Mike. So I was right out of school. I went and worked at a cement plant, so I was an environmental engineer. And then I became a process engineer there. And I decided partway through, I was trying to figure out if I wanted to do an MBA or if I wanted to do law school. So I ended up with law school, and I knew I wanted to do something technical. So I was between environmental law, because I'd had a lot of experience doing that, and then patent law. But I had some people in my class who were clerking full-time, and so I was going to law school at night and then working during the day. So I switched over midway and ended up clerking full-time at Harness Dickey. And I've actually been there ever since. So I graduated in 2003, and I've been doing patent prosecution and a little bit of litigation, but mostly patent prosecution, opinions, and then I became partner in 2011. So I've been there a long time. So, and Mike and I go way back. So we clerked together.
2002.
Yeah, long time.
Yeah,
so it's been a great career. I made a great choice. Environmental law has a very different dynamic of compliance, and I'm glad I didn't choose it. So I don't know if you guys are thinking about it, but that's just my plug for patent law. It's fantastic. Like, you get to use your writing, you get to use your technical experience. So I love it, and I'm glad I chose it.
Well, my name is Cesare A. Sclafani. I'm a partner at Dinsmore and Scholl. My technical background is mechanical engineering from Oakland University, and Oakland University is right by the Chrysler Tech Center. So you would see classmates graduate and come right back the next semester starting a master's program at night. And that kind of was the name of the game at that point was, bachelor's in science wasn't going to do as much. So I was looking into an MBA or a master's and I heard about, patent attorney. And I looked into that and I figured I would like that. So I ended up coming to Wayne and started off at Gifford Crafts in my 3rd year. And we recently merged with Dinsmore and Scholl in last year. And they are a large firm, primarily in the Midwest, so Ohio, Kentucky, and West Virginia. I love patent law. It's one of those things where you get to use kind of both sides of the brain a lot of the time. And I think of it as kind of a puzzle. You have the claim, what can you add, what can you take away to make it fit in with the client's expectations, but avoiding prior art. So I think that's my plug for patent law.
And I'm Mike MacCallum. I graduated here in 2011. I'm at Brooks Kushman. And I kind of fell into patent law, really. I started at Michigan State undergrad in mechanical engineering and had great experience there and started work for Continental Automotive up in Auburn Hills. And it was really, at that time, nothing against Continental at all, but I couldn't see myself kind of sitting in a cube looking at the same, little part for the rest of my life. So I decided to hop into law school, and then patent law was kind of the next progression, I guess. And so after starting at Wayne State, I started clerking at Brooks Kushman. I've been there since 2008, and I've had great experience there. And I echo what these two said. It's the same sort of thing. I have, litigators have these cases that go on for, 2, 3, 4 years, and in patent prosecution, it's almost like every day is its own mini litigation, if you will, because you're handling these battles with the patent examiners, you're handling battles with clients, you're handling battles with the patent office judges as well. So it's kind of like cram everything from a trial or from litigation into 1 or 2 days, and then keep doing that every day. I like it.
My name's Mark Frentrup. I'm a chemist by training. Had no interest in patent law or law at all when I went to school. Got an undergraduate degree from the University of Texas in Austin, and then came to work in graduate school at Michigan State because of a professor connection. That's how you always do it in science anyway, in college. Where you go is depending on who taught you the time before. So I wound up in Michigan, got a job in the research labs of BASF in Wyandotte. Stayed there a long time, and after 5 years or so, 5 or 6, got the opportunity, I think it was even a promotion, but it was an opportunity to get into the patent department as a searcher, using my chemistry knowledge and my relationships with the researchers. So that was fine, and I did that for quite a long time, maybe 10 years or more. And finally my brain, which it never had before, finally my brain said, law sounds pretty interesting. So it all came to pass, and I came here to law school at night while working in the day. And I loved every course I took, believe it or not, except, well, there's a few, but I took them pass-fails that didn't matter. And then finished my degree while I was still with my employer, but an opportunity came to join Harness Dickey. And I knew some attorneys there because they had worked on site, when we were inventing stuff, they had come and written some of our patents. So that's the other thing, there's always a connection. And I've been there since 2000. I do almost 100% patent call it preparation and prosecution. You write patents and you fight with the examiners. Don't do any litigation. I'm not worth very much in litigation, and don't do any trademarks. But for me, if I was your age, I would say no law school for me. But once you've already gotten to law school, so patent law is really a natural extension. The stronger you are technically, the better it is also for IP practice.
Well, I'm going to be a really interesting foil then, because I just graduated from Wayne last May. My background is more in biology. I'm much less technical than people I'm lucky enough to work with at Brooks Kushman. So my practice is more litigation and some of the softer IP, like trademarks and copyrights. because my background is in biology, in Michigan, that's a really hard area to try to get some of that kind of work for prosecution. So for me, the natural flow tended to be more litigation and the trademark end. As a first year though, I've had the benefit of kind of trying it all. So I think it's great that you guys are here and getting a panel full of all sorts of different types of perspectives, and I'm happy to speak less on we have a lot of skilled practitioners here, but I'm happy to speak to what it's like to be a first year IP attorney. So congratulations, you're all here, and best of luck.
That goes to I want a quick survey of the audience, because I've run into this before when dealing with law school students that show up for an IP discussion, and then you have 5 scientists on the panel, and everyone's saying, hey, what do I do if I'm not a scientist? How many of you have a hard technical degree of some sort, whether it's engineering, chemistry? So how many of you are also interested in careers in IP without the hard science degree? Okay, so, and how many of you have taken patent law as a course?
Take patent law even if you don't have a technical
Yeah,
degree.
you've taken the class.
Kathy
Yeah.
White's amazing.
Have you taken an intellectual property generalist class where you go over the 4? Okay, so it might be helpful to go over just quickly that intellectual property typically covers 4 categories, one being patent law, the other being trademark law, copyright law, and trade secrets. Obviously, this panel is particularly heavily involved in patent law, which you'll find at almost any IP panel discussion, because it's a hot area. It's an area that offers a lot of job security, and there's a large need in the market, right? And the reason is, to be a patent lawyer, you need a technical degree. To do patent prosecution, you have to pass the patent bar, and in order to sit for the patent bar, you have to have a technical degree of some sort. So it's a very specialized area with a high demand and very small supply. At least that's what drove me to go into law school. In order to do patent litigation, you technically don't need a science degree. You can have a general, you can have an English degree and go into litigation. Some of the best IP litigators in the field have strong litigation, strong writing skills, strong presentation skills, and they just gravitated into the IP field. And you'll find that at probably at Dinsmore. You'll probably find that at Harness Dickey. I know that the lead litigator, he was a non-scientist at Harness Dickey at one point. I'm sure you find that at Brooks Kushman too. So we can sort of, now that we have an understanding of where you guys sit, kind of drive the discussion in those areas as well. But how many of you are first years? How many of you are third years? And how many are second years? Any fourth years? Okay, good. So, going back to, why don't we start on this end, so we'll snake it back this way. Can you talk about some of the best advice you would give yourself as a law student?
Well, since I was just a law student, no matter where you are in law school, I think it's really, really important to get practical experience, even if it's not the experience that you're gonna ultimately be pursuing long term. I started clerking at Brooks Kushman in my first year of law school, and it was really invaluable to me because when I graduated, I was really able to hit the ground running. I took the bar, I came back 2 days later, and there was a full plate of work for me to do stuff, and it was, it's really helpful because when you come out of the bar, you're gonna feel really excited to do something. You're gonna be armed with this arsenal of tools, and you're gonna wanna go out and change the world, and you don't really know a lot. And now that I'm completing my full first year of being a lawyer, I'm realizing more what I don't know than what I do know. And that lends to my next point, is make sure you're surrounding yourself with really strong mentorship. I think Wayne does a really good job of connecting you with the community, especially the alumni. I think everybody's really happy to help. Even if it's just like, hey, what do you think about this? Call people, develop a network of people that you can do that with, and network with your classmates. I get a ton of referrals from people I graduated with law school with because I was the IP attorney. So really network with your friends. The people who are sitting next to you are your referral base. So that would be my best advice to you right now.
Yeah, I was thinking over in my mind what I would say, but the thing that you said about the referral base, really, really important. Not this year, not next year, but in 3 years, 5 years, 10 years. Just keep in touch with everybody. I also think it's extremely important to have as much practical experience as you can. Even to, Jennifer, didn't you say you quit your one job and
Yeah.
for the big bucks of a clerk?
Take a pay cut.
I was in a patent department, so my colleagues were patent attorneys, so that was a huge help. It's just, you need to do it. It's tough when you're competing against others who have the experience. I mean, imagine competing against her, and you haven't had any practical experience. It'd be very difficult.
I got a couple things. One would be, for sure, I know a lot of people will raise your hand about what classes you've taken and what you haven't. And I think if you have any interest in any of the intellectual property fields, take every IP class that we have here, because there's not many. There's 4 or 5 maybe. Take them. It certainly would show up as maybe a slight red flag if somebody's looking at a resume, you sound very interested in patent law or IP litigation, and you've taken one IP class. So for sure, take all those classes. And the other thing is attend things like this and find out, the guys at Brooks Kushman probably hated me when I was applying for jobs in 2008 because I was annoying and relentless to talk to them, and I found out who was on the hiring committee, and I did all those kind of things to really get an edge on people that are just submitting resumes to the pile. So get in and be relentless, be annoying, and say, just get me in front of you for an interview. You want to hire me, trust me, that kind of thing. Instead of just, because I've seen the stacks of resumes that probably every firm around here gets, and there could be any day 50 of them sitting there, and you don't want to be just another name that's on there. You want to be, oh yeah, I remember this guy. He's the annoying guy who's emailing me or calling me or doing this and that. Let's get him in here to shut him up, and maybe we'll like him.
I echo that.
I'm going to echo a lot of what was said before. If you can get face-to-face contact with somebody at a firm, that way when they see that resume, they think of a face. I mean, that puts you a leg up like you wouldn't believe. Not only keep your contact network from law school, just keep going on it. Keep getting involved with your friends and your fellow classmates. Get involved in a section of the bar society because that expands your network in any way possible. And it's very slow maturing process, especially with young lawyers. Young lawyers typically don't have a lot of clients initially, but when you start needing clients, your network will have clients, and they will have patent issues or IP issues, and at the very least they'll direct them towards you if possible. Practical advice for a law student, take the patent bar. That's a big feather in the cap when you get a resume, when you can put your registration number. It shows that you have an interest, you have the ability, and for inside for a firm, you get to charge more. You get to charge more for you as a patent agent rather than a clerk. So that's a big thing. And if you're submitting a resume and for an IP job, an IP position, don't list a society that's non-IP related, because that kind of questions your sincerity of whether you really want to do IP work. Just some insider stuff.
Yeah, I agree with everybody's take. I especially wish I had taken more IP classes. I only was able to take the patent law, the patent enforcement. I wish I had been able to take more, but I was an evening student and copyright trademark was during the day. So I kind of had to teach myself, and it really would have been nice to have taken those classes. One thing, so I'm on the recruiting committee at our firm, and so we do see a lot of resumes. It helps to know that someone's serious, if they're in the right groups, if they've had an internship. Taking the patent bar is a huge one, right? Like, we know you're committed. Because a lot of times people dabble, and that's fine. You want to know that you like the work. I think having an internship, I was lucky because I kind of fell into it early on, and I actually hadn't taken patent law yet. So I was able to try the work, and I liked it. But you really should try, like, especially if you're going to do patent prosecution, make sure you like it. It's very detail-oriented. So having that internship helps to build your resume, and helps for you to decide if you like it. The other thing about patent law is it's very much an apprenticeship. So when you're at the firm or even in-house, it helps to know, are these people going to mentor you? Because it takes a lot of time to become proficient in patent law. So having someone who's going to invest in you, train you, is really important. And it's something I realized after the fact I had, but if you didn't, you might not succeed. So that would be my advice.
So when I think of patent law and what I teach to I adjunct at another law school in Michigan, and what I try to talk about on the first day is I like to break patent, and this is my own opinion, not necessarily that of the panel, but I like to break patent out into patent acquisition and patent enforcement, right? So you obtain a patent, it gives you this exclusive right to a innovative technology. And those of you that do litigation will be heavily involved in the patent enforcement aspect. A lot of the panelists that primarily, when they say patent prosecution, meaning that they are primarily involved in the patent acquisition standpoint, and that involves everything from meeting the inventors, talking to the clients about what their technology is and what areas they want to pursue, all the way through, like Mark mentioned, arguing with patent examiners, or like I like to say, cooperating with patent examiners to obtain the actual patent from the patent office. So would the panel like to maybe talk through what a typical day is, or how you sort of engage your week, your month, your year as your career, whether you're doing litigation or patent acquisition or patent prosecution, and you know, some of the things that stand out as what you really enjoy about your job.
Perfect.
Maybe we can start with Mark and then move it the other way.
Yeah, one thing that I wanted to, everybody's talking about the courses, and I'm seeing Lewis out there who I reacquainted myself with. There is a patent drafting clinic here, which is excellent. And if you can get into that, that's very helpful. He did a patent actually for a relative of mine, and it was good to interact with him. So that's that. Patent prosecution is writing new patents, and it's negotiating with the examiner, who is a U.S. government employer, to obtain claims that are novel and non-obvious over everything that's gone before. And my typical day is probably spent more in actual prosecution rather than in preparation. But preparation of writing of a patent means getting the disclosure materials, calling up the inventor, maybe going out to meet the inventor in person, just picking their brain and interviewing them fairly extensively for a few hours, just to see what they've invented, and then you try to put that in proper form. You write claims and that sort of thing. The prosecution is pretty severely time constrained, so there are deadlines. So the docket system just keeps popping up deadlines. You know, if there's 100 files you're responsible for, there's going to be a deadline on some of them every week. You know, so they just pop up, and you take it in order, and you try not to do things too last minute. Others are going to give you, I'm sure, details of what it means to negotiate with the examiner. But the thing to take away there is I don't go to court, and I don't have too many high stakes meetings with people who are going to be angry at one another. So I'm out of the litigation area and into throw the red meat over the door, and then the work product comes out.
But not to interrupt, to continue on Mark's point, he's meeting with inventors. Inventors are typically, when you're representing a company, going to be scientists who have been practicing in this particular scientific area forever. For example, we're in Detroit, so several of the panelists have automotive-centric clients, right? And they could be either heavily involved in mechanical engineering, electrical engineering, chemistry or chemical engineering, and of course there's other technical areas too. But what Mark mentioned earlier, which I want to flag, was that the more technically strong you are, the better you may become at patent law. And there's an advantage there, because Mark's walking in with his Ph.D. in chemistry, but he could be talking to an inventor who's been working on this combustion aspect of an engine for 15 years. And that guy's a super expert compared to Mark. So, there's your technical ability is strong, but you're also going to be dealing with some pretty hardcore scientists in work.
I'll pick up from there. I like Mark, at the beginning of my career, most of it was patent prosecution, and I didn't really talk about this when we were introducing ourselves, but I'm starting to do more litigation. That's just because of the flow that your particular client might have. So, it's an interesting story with the case I'm working on right now. These tables we're sitting in front of right now, we have a bunch of these plastic tables like this at the office because we have a client who started manufacturing plastic tables. You go to Target, you go look at a banquet table, you'll find a, like an 8-foot-long banquet table that folds in half. They make those for Target and a couple other companies as well. And they're just a little 10-employee company in Southfield, local to us. We started doing some design patent work for them and some opinion work for them. And lo and behold, they get 2 patent infringement lawsuits filed against them within a month from each other. And so, okay, now I got to put on my litigation hat for the next couple of years while I'm doing patent prosecution, because this is my client. I do want to get involved in this stuff up and down. So, and it's not like some weird transition to go from one to the other or back and forth. There's litigators in our firm too that, there's a lot of ebbs and flows in litigation, and they, if times are low for litigation for a few months, they start back up in the patent prosecution realm for certain of their clients that they like to do some of that work for. So, just pigeonholing yourself in one versus the other isn't really, it doesn't happen for everybody, to say that.
Well, my area of practice is primarily patent prosecution. And starting off as a new attorney was primarily patent drafting. So you write the application. And you do that a lot because you have to get good at it. You have to get, not only good at it, but timely at it. And then after a while, a lot of these patents that you've written, they go through the process, and then you get an office action. So then you start doing some prosecution in terms of negotiating the patents in. It's always good, to channel what he would say, knowing the litigation side. Because you can't pigeonhole yourself. Because you're not an effective counsel to your client if all you know is prosecution. And they say, hey, we have a litigation issue. Well, I can't help you there. You have to go talk to somebody else. And that's not a good thing. That's not a good thing for the business of law. So.
Yeah, I agree. So I started off doing application drafting, prosecution. I still do that. I love it. I love the process of sitting down with an inventor and you're kind of vicariously living like their technology, right? And they come up with these new things, and it's fuel cells and batteries, and so that part of it I geek out, right? I love talking to them and writing the application. But early on, I think I probably did litigation support for about 5 years. I also love research and writing and doing motion practice. Litigation is very adversarial, obviously, and the schedule is a little bit difficult. It's a great experience just in terms of seeing both how you negotiate, understanding how the patent can be attacked, because I'm drafting them, I'm also seeing there are all these vulnerabilities in a patent, so you have to be worried about that. Obviously, being able to counsel your clients, but it's always, well, in my view, it's hard for the business. It's distracting from their business concern, and so litigation is difficult. And at the end of the day, I now do more patent prosecution, the application drafting. I do a lot of landscape strategy. So there's the aspect of getting your patent, but just because you have a patent doesn't mean you have a license to practice it. So you also have to look at all your competitors out in the world and see, do you have freedom to operate? So you're looking at huge portfolios and trying to assess the claims to see if a client's launching a new product, are they able to do that? And sometimes you'll have patents that are blocking something they want to do, and then you have to look at, well, how am I going to attack this patent? Is it invalid? Do we not infringe it? Do we push it into what's called post-grant proceedings? Do we push it into litigation to challenge the validity? So there's a lot of kind of chess game strategy that goes on with that kind of work, and I really enjoy doing that. I would say my practice is kind of a mix of doing the opinion work, some agreement work, and mostly patent drafting and prosecution stuff, just because I like doing it. But yeah, it's definitely good to be a well-rounded counselor, to see it all, to see the litigation. You can balance it, you can do both, but it helps your client at the end of the day, I think.
Well, so to look at what you guys will most likely be doing shortly, if you're not already clerking, as a new attorney, you don't really have the benefit of having your own client, your own docket. So you're really beholden to the partners and attorneys that you surround yourself with within your practice groups at whatever firm you're working with. So the good and bad part of being a new attorney is my days very rarely look the same, especially in light of the fact that I do about 50% litigation work. So with litigation, the pace is consistently changing. You'll have 2 months where you won't touch a case because you'll be waiting for X, Y, or Z to happen. And then sometimes it's like you're, boom, 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 and it's crazy. When I do prosecution, whether it's trademark, patent, or copyright, or things like that, it's generally, it's a lot of interfacing with clients and opposing counsel and things of that nature, but as a new attorney, you don't really get the benefit of the consistency unless you're going into like a patent internship program where they really have a system where you're going to be doing, you have your days a little more laid out for you. But I think for the most part, from what I'm hearing from my counterparts of like the 2015 graduating classes, you're going to be doing a lot of different things, and you're going to have your hands in a lot of different pots. And I think it goes to the rest of the panel's point is you become a really well-rounded attorney within your first couple of years of getting out. So you have to appreciate the chaos a little bit and be open to trying new things and getting those new skills and taking the time to really perfect them and learn from the people around you.
We made it all the way around. So, as you can tell, everybody here has a science background. I'm curious to know how you guys see yourselves as a scientist versus actually being a lawyer, and how you sort of juggle those two. And some of you touched on it a little bit from the standpoint, I'm glad you did, that it's not just the nuts and bolts of here's my invention, here's my disclosure, give me a patent on it, versus actually trying to counsel them, right? So I'm sure some of you have had classes where I would hope your professors have said something like, there's a difference between a lawyer that understands the black letter law and a business lawyer who really understands their client's business and understands the business they're in and what they're hiring you to do, because lawyers are very expensive, and a lot of clients don't like paying for them unless they somehow appreciate the value that they're receiving. So I'd love it if you guys could talk to that a little bit about how you balance, or what part of your job is scientist versus lawyer.
Yeah, and business too, because like you're saying, especially with smaller clients, if you're more heavily involved in the kind of showing them how the value of these patents are going to affect their business is a huge reward for them, and they'll just keep coming back to you. But yeah, about scientist versus lawyer, it is a mix between the two, right? But I mean, I kind of see it as you really start off the whole patent drafting thing as a scientist, and you're meeting with them and you're talking with them and trying to figure out what is the invention. It's kind of the first thing. What do they think the invention is? And then you go back and forth and you can talk to them about, could you do it this way? Can you do it that way? Why not this? Why not that? And you can really get them to start thinking about other ways to do the invention that they may not have thought before. And how that helps is because it'll help you kind of broaden out your eventual patent. So I think you kind of start off more of a scientist, and then once you're kind of done with them, you shut the door on them. Now you're working with like the patent office during prosecution to get this thing, and you'll still be talking with them. Hey, I need a couple questions. All right, I need a couple questions answered. I got the examiner saying this. What do you think about this? Is he right here? And you kind of put your scientist hat back on. Then you put your legal hat back on when you're talking again with the examiner or with their bosses, with the appeal board, or with any other post-grant proceeding, things like that. So you do really switch them back and forth a lot, or wear them both at the same time. But I do think you kind of start off at the very beginning more as a scientist, and then as your patent application is starting to turn more into something that might issue, a lot of it is because you have the legal hat you bring is a lot bigger than the scientist one you had before.
How many have work experience in your undergraduate field before you went to law school? Not too many years, but that's very valuable experience, whether it's in the technical area or whether it's in the business area, because if you know how businesses or corporations run, it's very helpful. So that's something if it's relevant experience, that's something to play up when you're looking for positions and trying to put yourself this much above anybody else in that pile. Yeah, you need to, Wayne, I'm sure every law school teaches it very well, but Wayne teaches it very well that when you get a law degree, you're a lawyer. So it's fun to still be a scientist every now and then, but you never are only the scientist. You're always the client's lawyer. So it's a standard of honesty and straightforwardness and clarity. It's just everything. I like it.
I'll, from the litigation end, I'll use a little self-deprecating humor. I am not the scientist on the case. I'm fortunate enough to be able to defer. We have a lot of very technically heavy people at the firm. When I go into a litigation case, I really try to come in clean slate. I want to learn that technology. I want to know everything about it, and I want to pretend I know information prior to it other than my common sense. In litigation, less so than in prosecution, I don't really have to put my science hat on a ton, because my litigation practice is really a blend of patent, trademark, copyright, trade secret. So I don't always need it. Certainly it comes in handy, because I think when you learn how to think technically, even if it's not your area of specialty, you have the kind of thinking to come at it from a technical perspective. But I echo the sentiments that were given in the sense that you come out of law school and you're an advocate. So most of the time I think of myself as a lawyer, but my practice is just slightly different, so.
Yeah, so again, I think we're all sort of saying the same thing, but I think it's just part of who you are when you've had the technical training, you're an engineer. So it's part of the language of talking to your inventors, but a lot of times you really aren't inventing. So I mean, you can look at it and you can say, okay, well, you've thought about certain alumni models, have you thought about all of them? You're always looking to try and, I guess, get the broadest possible patent that you can. So you do rely on your science background, on your engineering background if you're doing patent application drafting. I will admit, there are times I miss doing the actual engineering. I was at a plant and, you could go out and kick the mills and, walk around and and it was doing the process engineering, right? And now you're sort of a little bit, it's vicarious, you're not doing the inventing, you're sort of helping the inventors to get their patent application and hopefully patent. So there is a distinction, and you are a lawyer, but you are still using your technical background, and it's a good mix. But if you really love engineering, you're not going to be doing engineering anymore. So.
Well, I think it's been said, you're an attorney, and you have a background in whatever technology you have it in, and you use it. It depends a little bit on who you're speaking to. When you're meeting with the inventors and their engineers, you will talk to them as an engineer or as a scientist, because that's what they understand. If you go in there as an attorney sometimes, they feel a disconnect, and you don't want that. You want to be able to have free-flowing communication between the two of you. And then when you're speaking with the client, you put a little bit heavy on the attorney side of it, because, okay, yeah, I understand the background of it. Okay, now, this is why you need it for your business. And that helps the client. And then it's a little bit of both with speaking with the examiner, because you have to explain to them in the technical terms while throwing the legalese at them too.
Yeah, I think Chaz makes a great point that this is going to be important no matter what area you practice in, but also in any aspect of your life. It's very important to know your audience, and those that are the most effective at knowing who their audience is and speaking the audience's language are going to be usually most impactful in those particular moments. But which leads to the next question, which is I think some people have already flagged the importance of mentorship, and I would love it to hear from you guys your own experiences with mentors or being a mentor, and how that sort of helped drive your career in any particular direction. And I always found it to be very critical that you have a really good mentor, and that you're also, in return, that you are a good mentor giving back. But as new lawyers that you will soon be, I think it's important to recognize that going forward.
Yeah.
Sorry, Mike, I guess.
Sure. I think, whether you want to have a job eventually, perhaps in a law firm or in-house somewhere, or even directly at the client, sure. But in any of these cases, I think you gravitate towards, it's like human nature, you're going to gravitate towards somebody that you like, somebody that you like working with too, and somebody has kind of open arms to kind of show you the ropes too. And so wherever you end up, just kind of find the right fit for you and stay on that path. I've seen people that have come in and they just are, maybe they aren't as open to speaking with everybody to find out where they actually do fit. Because, you know, if you go to a firm with 20 attorneys, up to 100 attorneys, it's not like once you get to the job, you're gonna have the attorney come knocking on your door saying, hey, let's see if we work out. You might have some of the attorneys that say, hey, I need this done, but it's up to you to find out who the best attorney is to work with at the firm, I think. And so, I don't wanna get too much into firm life, but if you are at a firm, that's one that I would for sure, that'd be some advice I'd give you. But as far as mentoring though, I think everybody starts off as a mentee, right? Whether you're clerking or your first year or even second year too, you're still bouncing ideas back and forth with the attorney that you're working with. You'll do a lot more listening than talking, right? But really, in patent law for sure, once you work with a lot of different people, you try to, and you start finding your own style of how to do things, because every attorney there's not like some cookie cutter way to do patent law, as there aren't with a lot of other law practices too. So you work with a bunch of different people and you kind of find your own style, and that's kind of being a mentee from a lot of different mentors and then coming up with like your own approach to how to handle things. I think that's, the only way to get to be a good attorney that way is to work with a bunch of different people that can show you different avenues to do that.
Yeah, find somebody who's really good and then try to be exactly like them. If you can. I was fortunate to have very good, I guess you could call them mentors, but they certainly were writing instructors early in my career when I had no experience doing it, and they were tremendous writers and helped me a lot.
I think it's really important to look at a mentor-mentee kind of relationship as like a very fluid, evolving process. You don't need to sit down with someone and say, hey, can you be my mentor? Just learn from everyone around you. And I think it's really important, going back to the idea of knowing your audience. Don't feel isolated to having mentors that are in the legal community. You could have business colleagues. You can have people who are going to all sorts of different educational programs teach you things that you wouldn't know if you didn't just talk to people. So I think it's really important to listen, surround yourself with really good people. I think going back to Mike's point, try a lot of people's different styles. You're going to hear a million different times your first year out of law school, don't do it this way. And then you're going to really gut instinct want to say, but so-and-so told me to do it this way. I did it this way finally. And you have to be okay with being flexible, because as the new attorney, you have to soak up all of these different styles and figure out really who you are and how you're doing it. Somebody at our law firm always says it takes about 6 years to really understand the language of IP. 6 years of being an attorney and getting your feet wet and not knowing what you're doing and being told you're wrong and learning from those moments. So I think it's really important to surround yourself by not only the people outside of your firm, but inside your firm. Network in both places, figure out who you work really well with, figure out who you don't work so well with. And be honest with yourself. Is it something that you're doing? Is it something that they're doing? And figure out how you can correct that and grow and adapt as a lawyer. Because you're going to be learning not only new law, because the law we learn in law school is not very helpful to us, like a lot of the time, right? I mean, patent law, I will say, I go back to that outline all the time. So if you do have the opportunity to take those classes, they help me as a starting point with my research projects all the time. But really the hard part of being the new lawyer is learning how to be a lawyer. I think Wayne does a really great job of like showing us how to practically apply some of these skills, but until you really until you stand up, I don't know if have anybody had Rosen for evidence yet? Okay, so how does it feel when you stand up the first time in evidence? Everything falls from the top of your head. So it's all about having those really good experiences and being really honest with yourself and asking for help. So.
Well, I can tell you, I was assigned a mentor, and he was actually in litigation, so he was a litigator. And obviously, as I've told you, I moved away from doing litigation, but the first probably like 5-6 years I did dabble in litigation. And he's actually still my mentor. He still gives me advice and tells me when I'm doing things wrong. It's pretty funny. So I get a lot of feedback from him. But I did gravitate. I think Mark and I actually had some pretty similar mentors, and it's wonderful people that really taught me, the nuts and bolts of how to do patent prosecution it does take 5 years to really become proficient. It takes so long. The learning curve is really tough. And just having people who are patient, who are invested in you. I have a mentor that left the firm. I'm still really close with her. I meet with her all the time. I miss her. But, I think one thing I just want to point out, I'm sure you guys have heard this, but so your mentoring relationships eventually will turn into sponsorship relationships. So if you're at a firm and you want to become a partner, eventually those are the people who are going to hopefully go to bat for you, right? And they're going to be the ones who are in the room or like, you need to make so-and-so a partner. So having someone where you transition, you form those relationships, and then eventually they become your sponsor is really critical, especially in a law firm environment. But I think even in a corporate environment for sort of going up the ranks. So mentoring sort of builds that sponsorship. So.
There's a lot of really good comments here. I'm trying to think of a couple that haven't been spoken. One thing I would recommend is try to find a mentor who's going to give you what you need, not what you want. One of my best was the one who was the absolute hardest on me. I mean, I learned by him telling me what I was doing wrong, not what I was doing right. And that pushes you to constantly try to evolve in the situation and constantly try to do your absolute best on it. And that's where you learn, at least for me. Don't be beholden to one. I think I have, coming up, I had a couple. I had one who was fantastic on the drafting, and I had one that was really good on the client development, relationship. So don't be beholden to one, see who does something very well, and see what you can learn from them. And then the other point I would say is, in the mentor-mentee relationship is, you know what you're getting from them. You're getting their experience, but it takes time out of their day. So you try to have to give back to them in any way possible. Kind of keyword, buzzword that's spoken a lot these days is value added. What can you do value added to the client? Well, what can you do value added to your mentor? What can you bring to the table that another associate or clerk wouldn't? And the one thing that I use now is I think about all the things that I would have liked to have known at that time. And that's what I'm teaching to the associates now as being a mentor to them, is giving them what I would have wanted at that time, remembering you were in their shoes, it wasn't that long ago, and giving them what they need to succeed.
Yeah, and I think Chaz and Jennifer brought up some interesting points in that. Actually, you guys all did, but one particular that I was thinking is that you go through law school, you guys have worked really hard, class has been really tough, and you're learning a lot, and you take the bar, and it's like, oh, I'm officially good enough to be a lawyer now, because the bar says I am. But you get into, when you go to practice, it's like you're a baby all over again, right? You're learning to walk, you're learning to eat, you're learning how to stumble, and all that kind of stuff. The fact that you get experience while you're in law school is obviously really important, and the more classes you give are going to be really important, because they're going to soften that blow. But no matter what, your first year, you're going to get a lot of partners that you're going to be doing work for that are going to tell you, you're doing this wrong. You're going to see a lot of red and you're going to see a lot of edits, and you'll go back and forth. And your ability to adopt and get along and take that criticism is going to be critical to your own learning, but also to the value add that you bring to the law firm. At this point, we'd love to open it up for questions from the audience. I'm sure some of you have been itching to ask questions.
They're law students, they all ask.
Right. Sure. If you want to introduce yourself too, and what year you are.
I'm Bob Billings, I'm a 3L here at Maine, and been lucky enough to work in the field for a couple of years. Thank you all for coming and taking time to down here. With the advent with the AAA and mentioning trade secret now is kind of going along with the trilogy of IP. It looks like trade secrets are being more analyzed now. Are you seeing that in your practice? How is that? Is that kind of becoming a pillar in the trilogy of the IP now because of what's transpiring in the law?
I would say absolutely. I mean, now whenever we have a litigation kind of evaluation, it's definitely within the context. Also, where it's really, really important is like the customs aspect. It's an extra tool that we can use when we're enforcing our rights to say, hey, you do this, and we're going to not only be able to, we're going to be able to see stuff. There's a lot of, not to get deep into the law, but you can file a lot with customs. It makes it easier. So it's definitely become, I think another tool that you learn in your first year of law school is I can sell my service, but I can also really cross-sell like Mike's service, for instance. Like I might not have the engineering, it's cross-selling. So the new law is definitely, it was an opportunity to be able to talk to our clients about something new, even if it was not something we could even offer to them at that point.
So for those of you who don't know, the law, patent law specifically, had a major shift in 2013 with the passage of a new law called AIA, which is the America Invents Act. And that's what he's referring to and what she's talking about.
Well, then there was the new Trade Secrets Act that
Oh,
came
yeah.
out earlier this year, which maybe I was talking about.
Well, it certainly increased the number of webinars.
A good exposure.
I think it depends on where your client is practicing. If they're sort of in the like biomedical field and the sort of personalized medicine, those areas I think they've really been considering going towards trade secrets just because a lot of the one-on-one issues actually, not necessarily through the AIA, but there's certain areas that have been much more difficult to get patents in, so I think they consider it, but trade secrets are tough to keep. So you have to make an investment as a client, so sort of a trade-off. But yeah, it's definitely, at least from my perspective, something that we're considering a lot more. So.
I'm a little bit different than a lot of people in the room. I'm a first-year graduate student in the chemistry program, and very quickly we'll be starting to figure out research advisors and develop some sort of scientific application. Now, I know that when you do research at Wayne State, your research is Wayne State's property and your advisor's property first. But what happens if your advisor agrees to put you on the property and you want to go forward?
You call a lawyer.
Give me my card.
We're gonna all be racing up to see you.
Yeah, we do. Your firm does lots for universities as well.
Yeah.
All universities have a policy. First of all, if you're an inventor, you're on the patent, and if you're not an inventor, you're not on the patent. Doesn't matter what your professor wants to say. So the law requires true inventors to be named. But in your engagement agreement with Wayne State, the professor has to be willing to assign, the interest in the patents to the university, and that would cover you as a graduate student. Almost certainly that's the way Wayne operates. That's the way 2 or 3 others that I'm really aware of operate. I think the way it works is that the university basically has first refusal. If they want the patent, they'll take it over, and they might or might not reward individual student or professor inventors. But it's not yours to go. It's not yours to exploit, and that's because of your employment agreement. Not anything to do with patent law. So lots of inventions come out of universities, as you can well imagine.
Some universities do have clauses where it will revert back to the inventors if they decide not to
Right.
Pursue it and try to commercialize it. So sometimes you might have the opportunity and then you pay for it out of pocket, but it depends on the agreement you have with the university.
Yeah, I have a client who's an undergraduate. And because he was an undergraduate, the law was kind of different. But it turned out that the university didn't want his invention, so yeah, they gave it to him, and he's now pursuing it on his own.
You're actually seeing that more now with a lot of the Michigan State, who I still keep in touch with, obviously. I actually still live in Lansing. But, and I had personal experience working with the Wayne State Tech Transfer Office because my previous job I was in-house, and we did a licensing agreement with Wayne State. And part of the question was, well, once we signed this licensing agreement, is the professor obligated to help us? And her response was, well, Wayne State incentivizes inventors, even on license agreements. So the university still owns the IP, but the university is not in the business of doing research and acquiring more students, right, educating. They're not necessarily in the business of manufacturing and selling widgets. So if they can create good licensing programs, that's a big bonus for the university. That's how they're gonna make money. And they often will, let's say, incentivize their inventors, which are the professors and grad students, by saying, when we come up with any license arrangement, we give this percentage to the inventors. That's often how it works. But it's up to you as a graduate student to go look at your own employment agreement and review that clause, and then just keep track of where it's going. Because the tech transfer office is almost always willing to talk to the inventors who are listed on the IP that they file.
Thank you.
So, I'm also from chemistry, but I'm a fourth year PhD student.
Good.
And I've been considering going to law school. So I guess my question is more for Mark, is how was the transition from, graduate student doing research, long hours, and I haven't taken a class in, over 3 years, so transitioning back to student.
Well, as I might have mentioned, when I finished my degrees, I had no interest in law whatsoever. It wouldn't even enter my mind, although I watched Harry Mason or something. But, I was very lucky to go to the biggest chemical company in the world and have a lot of good research experience with that. And I think that helped me a whole lot in my patent practice, just because it gave me a pretty broad background in things, and one or two areas I was even close to expert. So by the time 15 years later I went to law school, I loved it. And compared to chemistry classes or differential equations and that stuff, law classes are breeze. You got to read a lot. It's a ton of stuff, but as somebody once said, you're never not going to understand it.
I can tell you this also from my own experience. My brother-in-law is a Ph.D. chemical engineer who went back to law school.
Okay.
And he's great. The law firm he's at loves him. But in particularly the softer sciences, which I don't like using the word soft, but biology, chemistry, even physics, they often, especially in biology, want someone with an advanced degree. So you're almost, I don't want to say you're pigeonholing yourself, but you're almost, you're extra special. If you have a PhD and you're a law and you're a patent lawyer, all of a sudden there's certain clients like a BASF or other major pharmaceutical or chemical companies who only want patent lawyers with very advanced degrees, and that they get excited because then they have a PhD patent lawyer who also can talk to their PhDs in the lab and understand their inventions on a very high level.
Yeah, pharmaceutical companies are heavy with PhD lawyers.
Yeah, that's kind of, because I'm doing biochemistry, so it's kind of.
And it, when I said, there's a high demand and technically low supply meaning there's not a lot of scientists that want to go to law school. There's even fewer with PhDs that want to go to law school, so you'll be in a very special area that I think will make it very easy for you to get hired. So I think we had one more question.
Yeah, I'm also a fourth-year grad student in chemistry, and so I already think I want to be a patent lawyer. Is it a better idea to get some technical experience, like a practical work experience, sort of like what you did, and then try and work in it, or go to law school right away, like right after the PhD?
I would only recommend what I did.
Right.
So, but that's me. It sounds like you might be interested. I don't know if it's worth doing a postdoc year or two, or whatever. You're going to have to make that call yourself. All things equal, PhD and 5 years of industrial experience greater than PhD.
But if you don't want to wait, it doesn't.
Yeah.
I mean, most likely there'll be a job for you, and so it's up to you. Like Mike says.
Yeah,
what you're
yeah,
interested in doing.
you'll have to. And as I said, the law courses are long and it's a slog, but it's not hard to understand. I mean,
So-
still you win.
Yeah. It's 1:15. I think I'm getting the signal to wrap it up. If you guys want to continue one-on-one conversations, I think there's a class starting in 10 minutes.
And we'll move it
So
out into the
we'll
hallway.
move it out to the hallway.
Yeah.
Where the food is and so. Anyway, thank you guys. Thank you, panelists.